We have David Delugas is on Zoom, and I'm going to call on him next at the request of Representative Clark.
Thank you, Chairman Welch, and thank you, members of the subcommittee, for being here and everybody in support of this bill. I'm David Delugas. I'm a Georgia attorney. I've been licensed since 1984, and I practice almost exclusively in family law. In addition, I founded in 2013 an organization, a 501c3, called the National Association of Parents, which our DBA is Parents USA, and we represent the interests of all parents in America using only the U.S. Constitution as our foundation and guide. I would note for the members of the committee that last week on December 7th, at the request of a North Carolina attorney representing a mother, we filed an amicus brief in the U.S. Supreme Court. And part of that directly addresses the issues before this subcommittee. First, Parents USA is a secular, nonpartisan nonprofit located in Atlanta, and it exists to serve all legal parents, mothers and fathers, married or unmarried, biological or adoptive, and their children. One of the missions, and the primary mission, is to preserve and support the parent-child relationship by protecting the constitutional rights. It's our position that when children are deprived of significant time with each of their fit parents, children have poorer outcomes on all measures of behavioral, emotional, physical, and academic well-being, and their relationships with their parents and extended families. And such poor outcomes include drug abuse, depression, teen pregnancies, misbehaving, deficient academic performance, and increased incidence of physical health issues. And better outcomes come from parents having significant roles in their parents' lives and parents making the best decisions they can based upon their natural bonds of affection, which is what the U.S. Supreme Court recognized in the case that everybody probably should know or does know or should know about, Troxel v. Granville, a 2000 decision that was a plurality opinion. And we take the position that because of these better outcomes for children, when they have significant parenting time with each of their parents, and by the way, for those who don't know, parenting time is the term now used in lieu of visitation, because visitation was fairly insulting to the non-custodial parent. Our position is that trial courts must not be permitted to intrude and to micromanage families by imposing custody schedules that undermine the parent-child relationship. So to that extent, let me talk, the phrase that's in our society this time because of the pandemic is, let's follow the science. And I'd be happy to provide the members of the committee and anybody else interested a copy of the amicus brief. But almost a quarter century ago, 18 expert social scientists chosen by the National Institute of Child Health and Human Development recommended that parenting time be distributed so that it would, quote, ensure the involvement of both parents in important aspects of their children's everyday lives and routines, including bedtime and waking rituals, transition to and from school, extracurricular and recreational activities. And I have a citation for that. I won't take the time to read the cites, but I have all of that. And in social science, child well-being or outcomes are derived from these categories, and I just listed them. But the literal ones are academic or cognitive outcomes, including grades, attentiveness in class, and tests of cognitive development. 2, emotional or psychological outcomes, including depression, anxiety, dissatisfied with their lives, or having low self-esteem. 3, behavioral problems, including misbehaving at home, hyperactivity, teenage drug, nicotine, alcohol use. 4, overall physical health or stress-related physical problems, sleep, digestive problems, headaches. And also 5, the quality of parent-child relationships, including how well they communicate with and how close they feel to their parents. And I can go on and talk more about those studies, but in respect for everybody's time, and I'd be happy to speak to individual members or the committee at another time. One of the issues that comes up, and one of the reasons this bill is before you, I submit, is that because when one parent is awarded substantially the vast majority of the time with a child, that parent becomes the de facto, quote, gatekeeper. Gatekeeper is a term everybody should become familiar with. The problem with gatekeeping is that that's when the parent says, oh, sure, you can go spend time with your father And sometimes with your mother, it's the other way around. The North Carolina case is actually one where the father was the custodial parent, and he was the gatekeeper empowered by the court to allow the children to go with their mother anytime the father said so. And that is very often the case with mothers in the state of Georgia who have the vast majority of custodial time. The problem with that is if the the parent who's the non-custodial parent doesn't battle for more time, a child feels like they don't care. But when they battle, they're battling with the child's parent. When the child's parent denies access to the non-custodial parent, the boomerang impact that most of these custodial parents don't recognize is the child resents them and later in life ends up being estranged from the custodial parent. So this concept of gatekeeping is created by the courts, the trial courts, and so that's an issue. Now, obviously, if people aren't aware, about 50% of all cases filed in Superior courts throughout the state of Georgia are divorce or domestic cases. Therefore, there's a huge burden on our system. And by the way, one of the goals, I think, of the committee should be to find a bill that will pass muster with the Council of Superior Court Judges. They don't want their power curtailed, but they need their power curtailed. And in essence, what I submit the bill when it's revised, and I do think it needs some significant revisions respectfully, as well as OCGA 19-9-1, which is the statute that provides for parenting plans, what's to be included within parenting plans. And candidly, part of the language in this bill needs to be in 19-9-1. And then the child support statute also needs to have some language in it that references parenting time deviations, how it would be affected by the parenting time allocated. Here's the thing about kids. This is from one of the studies from the American Academy of Child and Adolescent Psychiatry. Quote, children often believe they have caused the conflict between their parents. Many children assume the responsibility for bringing their parents back together, causing the children additional stress. Vulnerability to both physical and mental illnesses can originate in the tragic loss of one or both parents through divorce. Now look, trial courts are charged by the state as part of a divorce to award custody jointly or solely, and then to figure out this parenting plan when parents can't agree. But here's what happens, and I do this both from my own experience and vicarious experience in my studies as well. Trial courts fail to consider the harm they're doing children by the parenting plan they're imposing on them. They only use the magic bullet words of best interests of the child, which according to the US Department of Health and Human Services Administration for Children and Families, Children Bureau, there is no standard definition of best interest of the child. And by the way, most people don't know this, and in fact, a lot of judges don't pay attention to it, but in OCGA 19-9-3, the statute that's the subject of this bill, it actually says best interest of the child, and it says and to promote the welfare and happiness of the child. And trial judges don't do that. If you read orders, they almost always just say, well, it's in the best interest of the child. But in order to promote the welfare and happiness of the child, judges need to pay more attention to the impact of the parenting plan they're putting forth. And too often they use best interest of the child. And now trial court judges and family law attorneys, and I'm one of them, understand that as long as the trial court judge uses the phrase best interest of the child and then says, quote, in order to prevent harm to the child, anything that follows those two magic phrases, the Court of Appeals in Georgia is constrained to overturn. In fact, there's a case from 2011, Blackmore v. Blackmore, I have no connection to it at all, in which the father and the mother were both prevented from attending extracurricular activities of the kids, school athletic events, dance recitals, anything, if it was not their parenting time. The impact of that on kids is devastating, and I could speak to that. But my point is, on appeal, because the father appealed, the Court of Appeals said, well, we can't touch it because the trial court said it was done in order to prevent harm to the kids. So let me speak to,
Let
there's
me,
a
let me,
case.
let me jump in right here with this question, what you're saying. Number one, the reason why there is not a definition for the best interest of the child is because it is supposed to be determined on a case-by-case basis at the trial court level. Is that not correct?
Yes, sir, that's
So
correct.
that's why we don't have that definition. Now, in your presentation of cases to Superior Court judges, have you offered and presented and been allowed to present witness testimony, expert testimony that goes to the points that you're making regarding um, split time or equal time being in the best interest of the child in cases that you've litigated?
Um, Let me answer that question by saying this. First of all, I think the bill should be amended so that it
So is that
provides.
wait a minute, is that a yes or no?
The answer is yes, and the reason that it's a problem, Chairman Welch, is this: not everybody can afford to bring expert witnesses in. Not everybody can afford to even litigate, much less hire an attorney. Therefore, we need to be considering not just the high asset divorce cases, high income cases, where they can hire the expert witness. They can spend 50, 80, $100,000 in legal fees, which is not unusual, by the way. But the other problem with that is judges still do what they want to do because they have the latitude under the law to do honestly anything they want to do. I am actually, this organization and I personally, as a family law attorney in Georgia, the social science doesn't actually speak to equal shared parenting. It speaks to these outcomes, these poor outcomes are come about when children have less than 35% of time with one parent or the other. So the bill I would propose would say that the trial courts must provide a minimum of 35% time with each parent, so 35 to 65, somewhere in that continuum, based on the logistics of the family, how far apart they live, the work schedule, the child's extracurricular activities, the location of friends, extended family. This gives trial courts more latitude, but understand that if you're going to go below 35%, which according to the social science is the point at which these poorer outcomes statistically arise, then the court has to justify it by clear and convincing evidence and not just be making it up. Incidentally, Chairman, the other part is that the trial courts and lawyers, we've all come to understand, quote unquote, the standard visitation schedule. That you hear that term every day in every Superior Court dealing with family law. Why? Because courts have come up with the every other weekend. Now it differs from judge to judge, and we have so many Superior Court judges in the state that you could have the exact same case in two different counties and have wildly different outcomes. Why? Because for one judge, standard visitation is 6 o'clock Friday to 6 o'clock Sunday every other weekend. For another one, it starts after school on Thursday to Monday morning. And it just varies from the judge to judge. Here's the other reason that legislature needs to provide guidance. And by guidance, I mean boundaries, gutters for these judges. As I was talking with, and I won't name him, but everybody knows who this lawyer is. He's a fantastic lawyer, family law, well reputed. He and I were chatting about it, and he said this: last week, a buddy of mine was a lawyer practicing law in, happened to be Decatur. This week, he's now a family court judge because he got appointed to be a Superior Court judge. And he had never practiced family law, but now he is making decisions about people's families, kids and parents. And that is true. In Fulton County, we have the family division. Well, what's interesting about that is Fulton County Superior Court judges rotate in and out of family court. And I will tell you, some of the judges that rotate in never practiced family law as a practitioner, and during their time on the bench, never heard a family law case. So when they get transferred into family law division, guess what? They have no idea what they're doing as far as family law, what's the best interest, and they're going to be over relying upon the lawyers in the courtroom, which means whoever knows the judge better or who's considered the more reputable lawyer, not the evidence. The evidence doesn't matter. It doesn't matter very often, and it shouldn't matter, because one of the goals I submit we should have is to reduce the battles between parents. And as it came up, money is always a problem. So one of the things that needs to be clear is if the motive is let's help the kids have a better childhood, and I wrote this in something every day a child is hurt, every day a child loses any part of his or her childhood can never be restored or replaced. That means that in these cases that go before the courts, why? For a divorce, for a legitimation in a custody schedule, why does it take 6 months, a year, 2 years, 3 years with repeated modifications over time? Why? Because parents can fight. If you allow parents to fight, if you give them basis to fight, if you give them reasons to fight, they will drain their bank accounts. Lawyers will enable and encourage them, and sometimes rightfully so. And other times it's just a futile effort. So I submit that we need to look at 1991, 1993, 19, if I'm 615 on child support, so that the parenting time deviation addresses these issues so that we come up, and either that or the Child Support Commission revises the data calculation so that standard visitation, which is what they use, by the way, Chairman, the Child Support Commission creates an Excel worksheet where you plug in income and health insurance premiums and other things, and it spits out this is the presumptive amount of child support. Now, how did the Child Support Commission come up with that? Well, they decided what is standard visitation, and here's the costs and the relative costs and this and that. But my point is, they're using something based on, quote, standard visitation, which presumably is what the Superior Court judges are doing. So one of the things.
Let me jump in.
Sure, sure.
You're going at great length here, so it's not really affording very much questions. So let me interrupt you and be mindful of the time of the crowd of people that have come out on a rainy day, left their offices to be here and be present, as opposed to coming in by Zoom. So let's be respectful of their time today. But it does sound like to me that there are situations where, and I can conceive of them, where a hard fast rule of 30% or 35%, as you've suggested, may not be appropriate. And those will probably be less likely. Those may be the anomalies in terms of divorce proceedings, but they may exist. In which case a court would find it hard pressed to be able to order 35%. Now, those that are here in the audience and online, you don't know me. And let me just explain to you that part of the job of chairmen or legislators is to examine the information that's provided to us from both sides, or as many sides, as fast as we can. So don't read into anything about the questions that we're asking. We're asking probative questions because we want to try to sort through as much of the information that's given to us as possible, so that we're making decisions that are as have the known consequences, as many known consequences as possible, as opposed to having consequences that we did not ferret out and we didn't identify that result in worse outcomes than what we had hoped for. If we don't do that, then we haven't done, I think, the duty of a legislator in terms of ferreting out what is good policy. So with that in mind, these questions are coming, will be kind of counterpoints and points and counterpoints coming back and forth. So please don't infer anything other than us trying to sort through the information that's provided. But in one sense, you're saying, Counselor, that you are that we don't have a definition, but you would like to put guardrails up and have definitions and have defined terms. And then the next statement, you're saying that we have council Superior Court judges and others putting together forms that are used by courts and used by attorneys to help calculate the amount of child support that may be paid, which creates a different level of defined benefits, if you will, a defined set of child support to be paid. It's important that we provide as much flexibility in terms of the legislation as possible, so that courts and evidence and information can be discerned on a case-by-case basis, as opposed to the counter is that some group, whether it's the General Assembly or it is a subsidiary of the Georgia Bar, or it is the Council of Superior Court Judges, creates a set of parameters, and one size does not fit all, and you run that risk as well. So you have to kind of balance these two competing interests: the interest of a unique situation for the parents and child, versus what we may learn through this hearing and others, that there are some there's pretty strong evidence that in a vast majority of the cases, the children fare better if they have at least 35% contact with at least one of the parents, obviously with both of the parents. So understand where we're coming from when we make those statements. Counselor, I'd like to let you go on, but I don't want you to filibuster
I
the
agree.
proceedings.
Can you give me 2 seconds, a few minutes just to address what you just stated, Chairman?
2 seconds was good. 2 minutes, not so much. Let's
Okay.
do a minute and let's call it.
We've seen a decrease in the amount of litigation when it comes to child support when the child support worksheets came out. That was a good thing. That's the legislature telling people what your child support is presumptively. So this bill would do the same thing, although I agree with you that family law lawyers and the Council of Superior Court judges are going to oppose 50-50 as a presumption. But I do think there should be a presumption that not less than 35%. And again, we maybe need to look at these social science studies so you can see what I've seen, would then create the situation where vast majority of cases will be between 35 and 65 for each parent. And only rarely would it dip below, and then there would have to be some compelling circumstances to justify doing that. And my last thought on this is, you should expect the family law section to not endorse any bill that would reduce the amount of litigation and fighting between parents, because that affects pocketbooks.
Let me just interject there. I'm gonna say that that those statements do a disservice to the professional men and women who serve in the capacity as a lawyer.
I apologize.
Understand. No, excuse me. I'm sorry. Your time's up. Understand this, that members of the bar have a high ethical duty to represent their clients and to represent the children in the course of that divorce, and their interest. The members of the courts of our state also have a high judicial ethical bar to meet in doing their jobs of applying the law and also applying the law to the facts that are presented to them. They are not psychologists. They are not sociologists. Some may be, but by and large, they're not. They're trained in the law and they're trained in trying to be equitable and fair and rational. And so I don't approve of disparaging comments about members of the bar that make blanket statements about why some group, the motives or interests of some group in terms of their opposition to any legislation. We'll let them speak for themselves in that regard. But it does a disservice to the public to disparage people that have done their very best in terms of representation. And while the laws in the state of Georgia may not be perfect and may need to be revised to address these concerns, that is why we have a General Assembly and that's why we're having this hearing. So I would refrain from those kind of comments, please, especially from a member of the bar. With that, let me move on to the next speaker, if I could. There's a question from Representative Chairman Silcox, and I'll let her ask that question.
Thank you, Mr. Chairman, and I really appreciate your comments because I have a lot of colleagues that practice in this area of the law, and so I do appreciate your remarks. And it is a very tedious job for many attorneys to represent people in these cases because it is about family. It is about a bad situation, and most people don't resort to a divorce unless it's a bad situation. And I personally have been part of several cases that so much of the reason for the case being brought were negative behaviors on one of the spouse's parts, and those negative behaviors were so dangerous to the child that I really feel very strongly that it's important that we leave this measure up to the judge to decide what's in the best interest of the child, because I really believe in our judicial system, and I believe that the character of either spouse is brought out at the trial level, and that is what is lasting, and ultimately the character of each spouse, in the care of these children is what should be paramount in their best interest, in my opinion. And I do think that a judge, whether he or she is experienced in this area of the law or not, that our judicial system provides for the proving of these witnesses and their character in court. That's all I have to say.
Thank you, Chairman. And I think that, and I don't want to get too far afield here. I think that the intentions of this bill are good and admirable. And obviously this issue, just by looking at the folks in this room, the sheer numbers of people that are here and the long list I have of people who are going to speak, this is an important issue. This is touching and impacting children. It is certainly touching and impacting parents, and particularly fathers, it appears. So, I think that it is our job as policymakers to look and try to analyze how we can draft and modify and amend the laws to be more effective in looking at the strengthening the family bonds. Certainly, divorce is not a desired outcome, but it does happen. And when it does happen and you cannot keep the family unit together, the bonds that exist between parent and child are important and significant, and they need attention where the current law is falling short of that goal of maintaining a strong, healthy, and productive bond between a parent and child, male or female.